on to a hearing, but I don't know what that means. If we could just.
Judge, and I did email Ms. Ripley and ask her, did she want me to stand in for her? But she said that she was here. She's just on the record in Judge Michael Hathaway's court.
Tell her, and so respond back to her and let her know that, no, I'm ready because I'm getting ready I'm ready. No, I'm not. No. You need to stand in for her. Ask her, is it an adjournment request? She needs somebody at this point to stand in for her. We know she's here, but so is Miss Taylor Coleman. She said she's ready. She's ready now. She said she's ready now. She just messaged us. Okay. She probably heard me fussing through the device. I said I was going, maybe 2024 is going to be the year. Miss Taylor Coleman, I was telling them the other day, I said, I was watching this trial, or there she is. I was watching the trial on Court TV, and the judge, her demeanor was so melancholy to me, but I had no desire to be that way. Like, I had no desire. And I was like, I wonder if that is how they want judges to be. Not me, not the judge from the East Side. Miss Ripley, I said she must have heard me fussing through the thing. 2024, I'm gonna do less fussing. Maybe if I might not, but let's just go with it. Okay, Miss Ripley, I'm ready. I'm ready. Look, I was getting ready to send a note to Judge Hathaway and say, you're not more important than me. Tell Miss Ripley to come on out of there. Okay. I'm ready.
Do you swear that the testimony that you're about to present is the truth and nothing but the truth under penalty of perjury?
Yes, I do, Your Honor.
Okay. So I'm sure you're aware we have had some discussion about what it's going to take to make sure that each parent gets the money that they are entitled to with child support. We've come to the conclusion that the cases would be handled for just current support only if there was an amount of $885 paid each month. And Mr. Anderson has stated under oath that he is going to begin making that payment. Now, of course, I just want to make sure you're aware that that's not going to take care of your $13,000 of arrearages, but what I'm trying to do is prevent that from continuing to grow, as well as make sure that the payments are being made for each of the children that are under a child support order. Okay,
yes,
have you, and go ahead.
I'm sorry. I know the last time we met last month, that number was brought to his attention of what it would have to be, and it still hasn't been at all. And I know he's probably going to say it's divided and it's allocated how it needs to be, but if that still doesn't take up the fact that it's just not consistent.
It is not.
And I think he made the payment, what was it, last night?
Yeah, it was pretty recent because it's not showing. Yeah, 12/14. Yeah, that's just yesterday. So we know, I understand what you're getting at. We know that the payment was made prior to court, and probably if there was no court, it probably would not have happened. So, and that's the reason why I'm continuing him on this calendar, so that we can get to the point where, these payments are being made consistently. I am willing to use my time to keep seeing him if he is going, because honestly, Mr. Anderson, the reason I do this, I'm waiting for you to mess up, because you're not showing that you are going to do this on your own. And we need you to get to the point of understanding that this is not going to go away. I do think that you're capable of paying it. You just need to make up your mind and pay it. This should be the first thing that you take care of. The moment you have made $885 in the course of a month, this should be the first thing, not your rent, not utilities. This needs to be the first thing you pay. Okay, Mrs. East?
Your Honor, it's a little frustrating that Mr. Anderson comes in here with counsel, and he's probably, I don't know if they're under oath. I don't know if they're under oath or not. But the fact that if he's probably going to say, Your Honor, can I speak?
I am not getting, ma'am, I lodged an objection. I'm not getting paid a dime for being here.
Right. You know, I know he's going to say that again.
And that's why I asked if y'all are under oath, because Your Honor, it's just ridiculous at this point. And the fact that he comes in here with counsel, if whether you're getting paid or not.
Okay. And I understand.
It's no intimidation, Your Honor, of that he does not care.
Well, it doesn't intimidate me. And, you know, and I'm sorry, Mr. Majeski, you know, I'm going to put a stop to everything, you know, right now. So, you know, we're just going to have to be here as much time as we need to be here to get things back on track. And that's all I can tell you, because we have rescheduled another reset for February the 2nd. I've already made him aware that at that point, I'm going to be looking to see that $371 was paid to get him current for December. And we need to have all of the money for January paid, so that, you know, I mean, if we begin to fall, you know, 30 days behind, then we can, you know, go ahead to step 2, which is to take out a warrant. And that's just the way that those are my only options. So that's what I'm going to do. Yes, Mr. Majeski.
Because I just want to make it very clear. I do not know this lady or the other lady. I've done nothing to intimidate anybody. I'm a professional. It's my job to come to court. I haven't done anything wrong here, and I resent the insinuation that I have.
No, I mean, and I don't think she's saying that you've done anything wrong.
If you're not getting paid, this is not work then, right? This is just something that you're advocating.
Well, no, we're not going to get into
Your Honor,
all of that.
Can I say one thing and then I'm done?
Yes.
Having counsel for a child support case is either you paid it and you're taking care of your responsibilities, or you're not. It's not very detailed, you know.
Mrs. Eves, yes, you're absolutely right. I mean, but I can't, you know, he has a right to counsel, so I have to give him that ability. Mr. Majeski has said under oath that he's not being paid, so I can only believe that he's not being paid. And we just have to move forward, because at the end of the day, the only thing that's important is that your child gets the child support that they should get. Okay, so we're going to work towards that and, you know, hopefully get this resolved.
Judge, all I want to do is keep my client in jail. Would you rather me have here to advise him and tell him that he needs to pay this or not? I mean, which way is more helpful? I've done nothing to try to get this child support reduced. I've done nothing to keep him from paying his child support. I just show up here to make sure I know what's going on, so I can properly advise him on what he needs to do. And we do that here this morning, Judge. I'm not doing anything nefarious. I'm not. This is just a friend of mine. We all help our friends in this profession. We've all done it.
Okay. And I understand that. And, you know, and I appreciate you being here, and I appreciate you telling Mr. Anderson, you know, hopefully every month that he needs to get this done, because I'm sure you would rather do something else with your time as well. And all we need is for him to increase this amount, you know, by a few $100s, which is probably just 1 or 2 cars, and you wouldn't have to be here. And Mrs. E's and you know, the other mother would not have to be here either. So, you know, the ball is still in Mr. Anderson's court. He needs to take care of his business. These are his children. Okay, last thing, Mrs. East, because I got a big calendar.
Okay, yes, ma'am. Okay, so so I think he paid $500 when it should have been around, yeah, $514. And I think you said last court that it had to have been at least, I think it was like 900 or
885 to take care of current support. I probably put in the arrears, but it just doesn't look like the arrears are going to happen. So I would be happy if we just could get to the point where we can keep our child support current and not increasing the arrearage amount every single month. Because although we're here, we're still increasing our arrearage.
Right. And then you said Superior Court takes care of arrearage.
Yes.
Okay.
Yes, and you do have $13,000 of arrearage, and yes, you can go to Superior Court, and I can't tell you how much, but they will do an order. They will take away, the driver's license and the taxes. They will move things forward. Okay.
And even if he's like illegally not paying his taxes, they'll look into that as well.
That I can't answer. No. Attorney Carson says no.
I'll take.
Okay.
And then when is the next? I'm sorry.
February 2nd, 2024.
February.
I'm sorry, you're going into a new year with this. Go ahead, Ms.
Yes, Your Honor.
Did you say that he had to pay $371 in order for all the cases to be paid?
For December.
For December. I mess up on math a lot, so I don't mean to. But it looks to me like it's more like $489 that he needs to pay in order for all of the monies, because he paid $196 on this one, $117, basically $118 on the other one, and basically $82 on Mrs. E's case. And when I added those up, that comes to $395. But he needs to pay $885 for all three to get paid up. So it looks to me like he still needs to pay $489 rather than $371. That might have been $371 might have been just for these two cases. But if he only pays for these two cases, they won't get paid without that third one.
Well, I'm not going to say my math couldn't be. The amount that I had for him for December that I thought you gave me was $514. So maybe that wasn't correct.
Yeah, it might have been just for these two cases. We needed to add in that third one.
Okay. Then. So we're going to go with the $395 for December, and then moving forward, you need $885 a month. Does that sound about right, Attorney Carson?
Well, it's $489 that he'll need to pay to get December up for all three cases.
Oh, $489. Where did I write that down? Okay, $489. I think what's happening is some of these are probably a previous month.
Unless he's, I think I heard something about receipts. Maybe he paid something last night that I don't know about. Maybe there's
he paid
about $504 last night.
Okay. Then that would take care of all of it.
No, but that was the initial $514.
That was the only payment made in December. That wasn't an additional. That was the only payment. Unless you're showing something else. Because I don't show any payments for December on my list for either parent.
Right. So in order to pay December for all three cases, it's $885. And he's saying he paid
$514. But it was just yesterday, okay. So you probably don't have it.
Okay, so I see where we're differing then. Okay, so 885 minus the 514. Okay, so it's back to the 371 that you said. Okay, I wasn't aware of that other one.
Okay, so yeah, 371 for December, and then 885 moving forward, and we are going to reconvene on February the 2nd so that we can make sure that this money has been paid. Okay. And and the other thing, Mr. Anderson, is try to, we all understand, you're kind of pushing things to the wire, but try to make your payment 5 days in advance so that, you know, we'll have the record of it on the paperwork and we don't have to kind of be hunting for things. Because as you can tell, that creates issues too.
And
okay,
yes,
just makes it longer.
And in my defense, I'm not waiting till the court date. Last month, when I made the payment.
Okay. No need to say anything else, Mike.
Right. Okay. So I'm going to dismiss you. Have a good weekend, and thanks again for your cooperation.
For purposes of the arraignment as to both matters, schedule these matters for pretrial on January 2nd. At 9:45 a.m. And counsel asked to bond.
Yes, Your Honor. I would like you to know that Mr. Collinson is currently residing in Lincoln Park. He is tethered through this honorable court already. He works at Bakersfield Restaurant in Detroit. He's not currently on probation or parole. He has no other pending matters at this time. And after speaking with him at length this morning, he did assure me that he would be appearing at all future court dates. So I just respectfully request that all that be taken into account when assessing a bond.
Okay, slightly confused. Your client is currently on a tether out of this court?
Correct. I believe for a PPO.
I may have arraigned Mr. Collinson on a PPO violation. Well, is that what happened, Mr. Collinson? I arraigned you on a PPO violation a few weeks ago?
Yeah, I still have tether to live.
Okay, right, because there's a Third Circuit Court, for whatever reason, the Third Circuit Court didn't have a judge to arraign you. And so this court did that. And as a condition of that bond, this court placed a tether to make sure Mr. Collinson wasn't violating his PPO any further. Okay. And I gotta tell you, counsel, I have no idea where your client lives. We have multiple addresses for him. And now he's told you there's in Lincoln Park, which is not any of the addresses we have. And in fact, he just filled out his financial affidavit and advice of rights, and he put a completely different address from there. So, sir, where is it you live?
I live right now between Lincoln Park and the address I put on that affidavit because we're still working on the house. But I live on Regina Street in Lincoln Park.
So why didn't you put that address?
Because all my mail and stuff for like court, like important matters is still, like even my car insurance and everything is through that address. So when I'm giving official or like, I gave you the address for a good reason because that's the address I need the U.S. mail to go there.
So how long has it been that you've lived in Lincoln Park, sir?
Like for the last couple months.
So when did you last live on Ledyard Street?
On what street?
Ledyard?
Ledyard. I still, between Lincoln Park and Detroit with the job, I moved out of the Ledyard apartment to 2071 Regina.
Sir, what are you looking for? Are you looking for something?
No, I'm sorry. There was someone behind me.
Well, yes, it's the court officer.
Okay.
Sir, I'm confused. So now you're saying that you live between Lincoln Park, Wyandotte, and Detroit?
No, ma'am, I live at 2071 Regina. My like the house is still owned in Wyandotte. We're still working on it.
So which house is it you're working on? The Lincoln Park house or the Wyandotte house?
The Wyandotte house is the one that needs the chimney obstruction and everything. The Wyandotte house needs to be fixed. So you're asking me why I didn't give you the.
Excuse me. Why in the world are you then putting an address to a home you're not even living at?
What?
You're providing an address in Wyandotte on your paperwork here, and you're not even living there because it's under construction. But yeah, you're not putting that address, you're not putting the address you're living at, you claim, on your documentation.
No, I should have, all right, on the affidavit, I gave you that address, it's all my mail, everything that I'm like not getting, I put at 3348 because I get that mail. 2071, I'm not getting my mail. It's like 3348 is my home.
3348 is what?
It's like home to me.
Who lives at that address?
Me and my fiance.
And what is your fiance's name?
Sierra Rodriguez.
Is that the protected person on the PPO?
Was, yes.
What do you mean was?
PPO is no longer in, like, there were several layers to that PPO. I don't know if you remember, but there were several layers to that. Several different PPOs.
And sir, you still have a tether on?
Yes, Your Honor.
Well, if the PPO was terminated, the tether would have been removed.
Right. So no, the PPO was terminated, but you asked me why I put my mail to that address and have different addresses. I'm trying to give you all the answers that I have, like without, like, there's a reason. That's not that I'm doing it to be malicious. There's just a lot going on here.
Okay, well, I can tell you that you're not returning the home in Wyandotte because as far as this court's concerned, there's still an active PPO.
Okay.
I don't have anything that would suggest differently. In fact, let me.
So what I would request, Your Honor, is if you could change that address on the affidavit to 2071 Lincoln Park. I'm sorry, 2071 Regina Lincoln Park.
Oh, the affidavit. I thought you said Alpha David. Okay.
Yeah, I'm sorry.
All right. Well, that's okay. So, and sir, you failed to appear on your other matter from 2022.
Correct. Because of the mail thing that I was trying to explain to you, I don't get. So now I understand why you're confused, because I'm a little confused as well.
Okay, well, sir, that was a completely different address. That was an address in Trenton.
Yeah, my family. I understand. So I need the ad like that. I need those addresses to kind of like. Your Honor, if you use the 2071 Regina Lincoln Park address, I'll receive the mail. I won't miss any more court dates because these are important court dates.
Okay, well, here's what I'm going to order. I'm going to order $7,500 10% bond on each of these matters based upon your previous failures to appear and based upon your inability to provide a specific address other than the Regina address, which is one of about 4 or 5 addresses this court has for you. And the court is not going to take your Wyandotte address, since that seems to be the home of the protected person that is the subject of the personal protection order that I arraigned you on a violation on just a few weeks ago. In the event you postpone GPS tether to the Wayne County Jail,
Your Honor, I didn't.
consuming alcohol or drugs.
Your Honor, I didn't violate it a couple weeks ago.
When did I read you, sir?
You said I violated a PPO order a couple weeks ago. If you check your Honor, the PPO violation is no longer in effect. There is no valid PPO circuit.
Okay, sir, when was it that I arraigned you on your personal protection order violation, sir?
The last time you did was in 2022.
Okay, I thought we just established that this was a few weeks ago that
So that's kind of my point. There is actually no active PPO, Your Honor. There is no active PPO violation. Me and that person have been in contact in a working relationship. As I said, she's my fiance. We've been together for the last 9 months since I've lived at Ledyard. That's why I gave you the address.
did you say since you lived at Ledyard?
Yeah, we've been, that was the, yeah.
Okay, well, the court doesn't have any verification as to where Mr. Collinson really lives. And based on his failure to appear previously, the court's going to issue a $7,500 10% bond on each of these matters. In the event bond is posted, GPS tethered through the Wayne County Jail, not to possess or consume any alcohol or drugs unless prescribed. Thank you very much.
Thank you, Judge.
Good day. All right, thank you. Okay, and then, Goldpaw, Mr. Goldpaw? Oh, no, hold on, we have another jailer. Okay. Right, we're on the record in the matter of the state of Michigan versus Daniel Brisboy, 232521. And Detective, your name for the record, please.
Detective Devin Geiger, Wyandotte Police Department.
All right, please raise your right hand. Do you solemnly swear from the testimony about the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. All right, and you may proceed on the warrant.
On December 10, 2023, approximately 2100 hours, officers John Ames and Austin Sloan responded to the area of 6th Street in Oak. Reports of a suspicious male running in the street and potentially falling. They were sent there on a welfare check of this individual. They advised that the male was wearing a black white striped jacket and tan pants, and doing push-ups in the street, running up and down the street. He's also carrying a duffel bag. They arrived and located this individual, matching his description, sitting next to a bunch of wooden pallets on the north side of the street. They approached the male, and he verbally identified himself as Daniel Brisboy. He appeared to be under the influence of an unknown substance. He's having difficulty speaking. He seemed emotional. Mr. Brisboy stated that he needed medical attention, which police officers then dispatched the paramedics to the scene. While speaking with Mr. Brisboy, Officer Ames asked if he could have consent to search the person. It is reported that Mr. Brisboy then granted consent by shaking his head in the affirmative. Officer Ames then located what he felt like a package in his coin pocket and removed the object, which is that he identified as a bundle of potential cocaine or fentanyl. They asked Mr. Brisboy what it was, and he confirmed it was fentanyl. This package was field tested positive for fentanyl. Mr. Brisboy was then arrested and taken to the Wyandotte Police Department.
All right, upon examination of pleading witness, I find the offense charges committed, probable cause to believe defendant committed the offense. Counsel, your appearance, please.
Attorney Corey Westmoreland, appearing on behalf of Mr. Brisboy. Mr. Brisboy, would you please state your name for the record?
Daniel Brisboy.
I'm sorry, that's a little muffled. Can you try that again?
Daniel Brisboy.
All right, and counsel, as to the arraignment.
At this time, Judge, we're prepared to waive a formal reading. My client stands mute.
The court will waive the formal reading. Sir, you have the right to have an attorney. If you cannot afford one, the court will appoint one to represent you. And in fact, you've had an opportunity to speak to an attorney today, correct?
Correct, understand.
You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury, and you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights?
Yes, I understand.
The court's going to enter a plea of not guilty on your behalf. Schedule this matter for probable cause conference on December 21st at 8:40 in the morning. The court has also signed your request for court-appointed attorney for felony matters and counsel as to bond.
Yes, Your Honor, I would like you to know that my client lives in Woodhaven. He has no other pending matters at this time. He's not currently on probation or parole. He is looking to get himself checked into inpatient rehab. And after speaking with him at length this morning, he did assure me that he would be appearing at all future court dates. So I just respectfully request all that be taken into account when assessing a bond.
Okay, Mr. Brisboy, why is your name familiar? Have you been here before?
A while ago, the other judge, but I was there, but not with you, ma'am.
Okay. Have you been here for any other matters, landlord, tenant, or otherwise?
No, ma'am.
Okay. And you're not working?
Not at the moment.
Okay, how many moments have you not been working?
Pardon me?
How many moments has it been that you have not been working?
It's only been a couple of weeks.
Where were you last working?
Weather guard windows.
Where?
Weather guard windows.
Have you ever failed to appear in court for any reason?
Yes, I have, ma'am.
And are those matters still pending, or did you take care of those?
I took care of them.
All right, Detective, would you like to address bond?
Yes, Your Honor. Just the circumstances of this, for this case, we would request a bond to assure his presence in court. We request at least 5,010%. Reason being, for reasons unknown, the prosecutor's office neglected to add an additional matter to this, which is, it appears that Mr. Brisboy's got a minimum 4 previous felony convictions, which would make him an habitual offender 4. He also has what appears to be 2 outstanding warrants for his arrest. One out of Lincoln Park, it looks like it was issued in 2017. And then another one out of Taylor, issued appears to be in 2020. He's got a Woodhaven address, so at this point, we just want to assure his presence in court. And the fact that he has these 2 outstanding matters, he's a potential flight risk.
Okay. So what is that, sir? Sir, what was that?
I said that the guy don't even know me. How can he's reading some paperwork? That's all he's reading.
Sir, I need you to speak directly into the microphone.
I didn't say
because I'm
nothing.
having a hard time understanding you. And what was that?
Nothing. I didn't say nothing.
Oh, I thought I heard some words out of your mouth. All right. Based upon all of that, the pending matters, and that there's prior felonies for similar convictions as well.
They're not similar conviction. This is my first drug offense. I have no similar convictions on drug prior offenses.
Let me clarify. When I say similar convictions, I mean felony convictions, sir. So I am clarifying that. The court is going to order a $7,500 10% bond. The event you post bond, you're not to possess or consume any alcohol or drugs unless prescribed. We'll see you back on December 21st. In the event you post bond, sir, just be aware that you are, sir?
Yeah, what? Yeah.
In the event you post bond,
I'm not posting bond, just what's been going on with this. I want to go back to the south. Sir,
Sir?
Yeah.
In the event bond is, in the event, can you please not interrupt? In the event bond is posted, you're to appear in person, not on Zoom.
Cool.
All right. Have a good day. Thank
Thank you,
you.
Judge.
All right, so what is happening with this case? I see that there are new cases, I guess, that have not been indicted.
That's correct, Your Honor. So Ms. Stern is charged with aggravated assault with a deadly weapon. We are on that indicted case. We're asking for a trial as soon as possible.
Okay.
And we're out of juries this week, but we're asking for the next court date available since she's in custody. Additionally, she did pick up 3 charges of aggravated robbery. Those bonds are set at $75,000 each. The state has no information beyond 3 sentences in a probable cause statement for the arrest warrant. She disputes those charges immensely. And one issue we wanted to take up with the court is on her aggravated assault indicted case that we're here for. She was remanded without bond. We're going to ask the court to set a bond in that case.
All right, why is she remanded without bond?
Probably because she picked up the violation report of picking up aggravated robbery charges, Your Honor.
All right, so with regards to the remand without bond, the court will be able to hear that. But state, when will you be prepared with witnesses?
It's time, Judge.
All right, we can set it on January 4th to have the hearing. And would parties be in agreement to allowing witnesses appear by Zoom or no?
No objection, Your Honor. That's not a problem, Judge.
Okay.
And, yeah. The 4th is fine.
All right, Norman, can you put this on January 4th for a bond hearing?
Yes, sir.
And Your Honor, is the bond hearing with the court here or with another?
Oh,
court?
we can have it here.
Okay.
Yes.
For the same day or just the bond?
Oh, for resetting it for the same day. It'll be bond plus discovery. Okay. All right, is there anything else? All right, anything else?
Nothing, Judge.
All right, thank you.
Thank you, Ms. Boyd.
All right, you're welcome.
Have a good day.
All right, you too. All right, who's here? Miguel Maldonado. Yes. We're going to go on the record, so please do not talk in the box if you're behind the court reporter. And if you are in the box, please whisper. Court is calling 2023 CR 2432, State of Texas versus Miguel Maldonado. Could I have parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Defense?
John Pettis for defense.
Are you Miguel Maldonado?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Maldonado, I'm showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, ma'am.
Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
We are, Judge.
Just one moment. This is the wrong phone. Oh. All right, Mr. Maldonado, I'm going to show you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of possession of marijuana, 4 ounces to 5 pounds as a state jail felony? The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine.
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
All right, counsel, I see listed in the paperwork Thomas Beck as the attorney.
I should have scratched out most of the places where he was supposed to sign.
Okay.
Sorry about that, Judge.
Oh, no problem.
Oh.
It made it to the next page. Thank you. Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Maldonado, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial, showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 16 months in the state jail facility. There's a $500 fine. State recommends community supervision. They'll take in consideration grand jury number 801464, which is the JN number 2142166, county court cause number 715777. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
Yes, Judge.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
No, Judge.
Next, I'm showing you outside the agreement. State is requesting that your community supervision be for a term of 3 years. There be a TAP evaluation and 150 hours of community service restitution. Did you understand that those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
State obviously exhibit 1 in all actions.
No objection, Judge.
All right, you may continue to confer. Counsel.
Sorry, Judge.
Oh, no problem. Mr. Maldonado, I'm showing you what's entitled Wavering Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
All right, court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
We just ask that you follow the agreement, Judge.
All right. Mr. Maldonado, do you have any children?
I got 1 on the way, ma'am.
All right. And how old are you?
Me, I'm 25.
Are you employed?
Not at the moment, ma'am.
When's the last time you had employment? And I mean an
I-
employment where you got a paycheck.
Probably like 3-4 months ago, ma'am.
All right, why are you not employed?
At the moment, it's because I lost my ID and I'm in the process of getting my social.
And if you're drug tested today, what are the results going to be?
I'm going to be dirty for marijuana, ma'am.
All right. So here's the thing. I can place you on probation, follow your agreement. Probation in here is, as the deputies tell me, it's not the easiest of probation because I want people to make changes in their life, right? You have an issue with gang affiliation, correct?
No, ma'am. I'm not a gang anymore.
So you just love Louis Vuitton.
What do you mean?
That tattoo on your head. You're just in love with the brand?
No, if you look at my theme, ma'am, when I'm incarcerated, I go inactive. You know what I mean? I'm not in part of the gang no more.
So what she's asking, is it a tattoo from your days in a gang?
Yeah, it's previous.
But you are not anymore.
No.
All right, because what I'm reading, all of the people in that vehicle are all gang members and active gang members, and that's what the surveillance was about.
He's not anymore, Judge. All you can say.
Well, here's the thing, you're gonna end up on gang supervision. So if you think you can complete this, you know yourself better than I do and better than your attorney do. I will follow the agreement, but again, being on probation here is hard. So if you want to, I can follow the agreement. If you don't, if you want to just do your time, I can sentence you to time.
No, ma'am, I want to follow the agreement because I got a baby girl on the way, ma'am.
Okay. All right. This is what the court is going to do. There'll be a $500 fine. That will be probated. 16 months in the state jail facility, suspended and probated for 3 years. We're going to do gang supervision. Take in consideration grand jury number 8014464, JN number 2142166, county court cause number 715777. Once they review your status, if they determine that you're not a gang member, you will not be on gang supervision. But they're probably going to show up in the system that you're a gang member.
Okay, but yes, ma'am, that's what I was gonna say, because in my previous record, like when I was incarcerated, I was in the gang. Last time I went down, I went inactive and stuff, so there shouldn't be no reason, you know what I mean?
Okay. Well, it's probably going to pop up as a gang member, right? So if it doesn't pop up, if they say that you're not, then he will be on regular supervision. You understand? All right, there's going to be 150 hours of community service restitution. How far did you go in school?
I only went to 6th grade, ma'am.
All right, so why did you only go to 6th?
Incarcerated.
You were incarcerated in 6th grade?
Yes, ma'am.
How old were you?
I was 13.
All right, incarcerated for what?
For my juvenile case. What was it?
What was the?
Aggravated assault.
Okay. All right. I'm going to ask for parenting classes. And either you're going to get your GED or you're going to do some type of trade school or something with your life.
Well, I was in the process of getting in barber school. I'm just waiting for them to see if they're going to approve me with the little Goodwill program that they got going on. You know what I mean? And I'm in the process of getting in that.
All right. So it's going to be one or the other. Once he's completed parenting classes or obtained his GED or his trade school certificate, then the court will deem the community service hours are satisfied. With community service hours, always try to give something in exchange for that, so for people to improve themselves. And we're going to do regular UAs. You're going to be tested for levels. So there is no marijuana use while you're on probation. You understand? And your child doesn't need to be around anybody who's smoking marijuana. The mother doesn't need to be around anyone smoking marijuana because it impacts the baby's health. You understand? There's to be regular reporting by Zoom or in person. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be no contact with the following: Eric, A-A-R-I-C, Arlie, A-R-L-I-E, Arias, Christopher, I, Martinez, and that's the letter I, Beto Hernandez, and Amanda Lorraine Enocio, Enocencio. I'm going to want field visits 1 time per month until further notice. And of course, probation, if he's on gang supervision will do the visitations as they see fit. Probation, is there anything else he needs? Yes, let's do a TAP evaluation out of custody. Follow TAP recommendations. However, if TAP recommends inpatient treatment, we'll start with intensive outpatient treatment.
Thank you, Judge.
And I'm going to ask for 90 sober meetings in 90 days. Anything else, probation? Is there anything else you need from the court in order to be successful? All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you sign it? Yes. All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. Probation in this courtroom, they tell me it's difficult. The key to successful probation in this courtroom is communication. If there's something that you feel needs to be addressed, talk to your probation officer. If you feel they're not addressing it, you can always come to court and address it with me.
Yes, ma'am.
And you need to make sure you report.
Yes, ma'am.
And what you've done, you and the future mother of your child have decided to bring a child into this world. So you need to be someone they're proud of, right?
Yes, ma'am.
And you need to make sure that they go beyond the 6th grade, okay? All right, good luck to you.
Thank you, ma'am. You too.
You're
Have a
welcome.
good holiday, ma'am.
Oh, thank you. Happy holidays to you too.
Yes.
I'm just gonna be me because I think I have it.
Okay, I'm change the rules. Who can find it second witness? Oh, you had it first? Okay. You're how do you pronounce your name, ma'am? Is it Lefebvre?
Yes, sir.
It's not Lafebre.
It's everybody pronounces it differently.
Okay, this is French, but it's Lefebvre is the way you do it, the way we do it down here, I guess.
Yes.
Okay. You have 3 cases.